Right, I'm going to be talking about legal learning. Now, this, I'm going to be talking about the Welsh laws, and I'm not going to give a detailed background to the law manuscripts, although I'll be talking about them in a very specific sense tonight. But this is something, some aspects of this are discussed in my book, The Growth of Law in Medieval Wales. But I've got sort of other sort of things I'm going to be talking about, but I'm going to be emphasising the importance of legal learning in general in medieval Wales. It's going to be about lawyers. I'm married to a lawyer, so I have plenty of knowledge of modern lawyers, but yeah, he's just popped his head around the door. But yeah, so I'm going to be talking about legal learning. And the quote, ni bydd ynad neb heb ddysc, roughly translated, nobody shall be a justice without learning. That's a quote that's found in one particular law manuscript, but it's not actually a piece of law. It's in a section discussing learning in a fairly general way. It's saying how a man should be wise and how, people, things to do to help you to be wise, avoid drinking and things, alcohol and things like that. But anyway, it's a little bit like a proverbial section, and you get those from time to time in the laws. Now I put part of that section up on the screen, and I'll admit, I have slightly doctored the quote, because what he actually says, what the quote actually says is, whoever shall keep these branches, these are the branches of wisdom, they're described as branches, whoever keeps these branches well and learns from the established law which pertains to them, they are worthy to be heard. Sorry, I'll just move, I am blocking the screen. They are worthy to be heard because of two things, wisdom and law together. And because of that, it is said, and here I doctored slightly, nobody shall be a justice for learning alone. That which a man learns ever, he will not be a justice unless there is wisdom in his heart. And the wiser a man may be, he will not be a justice unless there is learning with the wisdom. So you need two things, wisdom and learning. I'm emphasizing the learning. I'm not entirely sure how you learn the wisdom. It may be that you have to be born with it, but I'm going to be talking about the learning today. So what I'm going to talk about is the law books and what the law books say about the lawyers. Who were the lawyers? What did they do? And how did someone become a training, in brief? And I'm going to be looking largely at the evidence which comes from the law books themselves. And then I'll discuss the importance of the books to the lawyers and the importance of legal learning. So Welsh law is book learning. It's legal learning, and Welsh law is preserved in books. My quote is from Sir John Baker, An Introduction to Legal History. That's the sort of textbook for modern day lawyers who want to learn legal history, actually. Sir John Baker was Professor of the Laws of England at Cambridge until he retired a few years ago. And he states in his book, the literature produced by a profession is often the clearest guide to the state of its intellectual development. It is, of course, possible for courts and administrative systems to function without books, but it is impossible for a body of law to develop very far without the interposition of writing. Now, if the state of Welsh intellectual development of Welsh law of Wales is sort of measured in its books, then we are in a very good place indeed, because there are 42 manuscripts, at least 42 manuscripts of Welsh law. They are lengthy written books. The books themselves have a lot of content, is what I mean. They're long manuscripts, and they're books of written law, all written in complex and technical Middle Welsh prose on the whole. So they are sort of quite a treasure trove of material. There are also, I'm just going to mention in passing, 5 Latin texts of the laws. Now, that's a whole other kettle of fish, and I'm not going to be discussing that this evening, because obviously if you have law in Latin, then that sort of ties in sort of Welsh law into European traditions and broadens the audience of it, if nothing else. And it's a whole different sort of history. So I'm going to be talking about the Welsh manuscripts tonight. But from the start, if you look at the number of manuscripts and the type of manuscripts that we have for Welsh law, what we have is a clear situation that has sophisticated learning in terms of the law in Wales. We've got well-written books of law. They're advanced texts. We're not talking lists of rules like the 10 Commandments. These are sophisticated. They show thought, they show alternative thinking, they show problem solving and all of that. And it's also a scholarly legal system, drawing on wider European traditions of lawmaking. This is not sort of basic stuff. This is complex and, yeah, difficult stuff quite often. The law books themselves show that there was considerable legal skill and learning in Wales, in Welsh, and the work of the lawyers who created the books was highly intellectual work. One important point, the earliest manuscripts date from 1250. They date from around 1250, but there are no Welsh manuscripts from before 1250. And it's quite clear that the earliest law manuscripts dating from 1250 are drawing on earlier written texts. So the first survivals we have are around 1250, but we've got a tradition that goes before that, it's just not survived. So it's very much a written form. Now, Cyfraith Hywel, the legal system in Wales, is usually said to be lawyer-made law. I'm not disagreeing. Lawyer-made law, created for the lawyers, created by the lawyers for the lawyers. So the first thing I want to do is look at the lawyers and who they were and what they did in brief. So I've got a section of a manuscript here, which is lifted off the internet, probably with no permission to share. And that red bit is the name of a poet. So the first thing I want to do is look for evidence of the lawyers in Wales. And unfortunately, if I was stopping here, I'd be stopping fairly soon, because there's very little evidence for actual lawyers outside of the law books themselves, at least until the 13th century. But even then, there's not a vast amount of evidence for lawyers in Wales. But we do have the law books. We've also got genealogical evidence, which ties in with what we get in the law books. And what we know from the genealogies is that there were lawyers in Gwynedd in North Wales, Northwest Wales, during the age of the princes, and they were very important men. They were members of an academic elite, along with the poets, and the poets and the lawyers, bear with me on this one, the poets and the lawyers were very closely linked, and they were often from the same families. Now, here's a famous poet, Gruffydd fab yr ynad coch, I can't, it's Gruffydd, the son of the ynad coch, proclaims this poem. The poem, he's best known as the poet who wrote the elegy for Llywelyn ap Gruffydd, Llywelyn the Last, in 1282, who was killed as part of the so-called conquest of Wales. Quite a lot of Wales wasn't conquered at that time, but Gruffydd wrote the elegy, and it's a very famous poem. But Gruffydd's patronymic, he is the son of the ynad coch. Now, the ynad coch is the Red Justice, so his father was a lawyer or a judge even. And there is some evidence actually that Gruffydd also, he was a poet, and he's best known as a poet, but he was also quite probably a lawyer for Llywelyn ap Gruffydd as well. Didn't do his job well enough towards the end, but there we go. So you've got a poet that's the son of a judge. And poets and lawyers have a lot in common in medieval Wales because they were part of an intellectual group. They were very high-ranking men. They worked very closely with the princes. And the craft of poetry was probably passed down from father to son. Law was probably passed down from father to son in the same way, but it doesn't make much difference because they were all related to each other anyway. We don't have very much evidence for law schools in medieval Wales, but we can assume that there was some sort of setup, and there certainly was in Ireland. You've got a parallel sort of situation in Ireland, and they had law schools. No evidence in Wales, but we can assume that there was for various reasons. We've got more evidence for the poets and their training and learning because we've got surviving poems that are linked to the poets. So this poem, which is not the elegy, I don't think, this poem, we know it's Gruffydd ap yr ynad coch who wrote it. But the problem is you've got the poems, and the poems are written by, created by poets, named poets. With the law books, the law texts are not the work of one person. So you're not going to get one book that was written, one really lengthy book that's attributed to one person. There's usually, there's more than one person involved, and there's a longer tradition because poetry and law aren't exactly the same. But there are lawyers named in the law books, and this is one of our main evidence. Combined with the genealogies, we can work out a little bit about who these lawyers were. They were usually preeminent lawyers, famous lawyers. Now, the Welsh texts are organized into 3 groups known as redactions. They're all sort of manuscripts which are similar in order and content. And the names of these lawyers have been applied to the groups, and the groups are called Iorwerth, the Gwynedd group of manuscripts. The earliest manuscripts are from 13th century Gwynedd. Then you've got the Cyfraith texts, which are more South Wales and an earlier form of text. And then you've got the Blagorid texts, which are firmly South Wales texts and later in date, 14th, 15th century texts. But they're named after lawyers, Iorwerth, Cyfraith and Blagorid, and they're named after lawyers who are named in the prologues to the texts. Now, I've said these names, and actually, if we look at this genealogy, which is taken from David Jenkins's journal article on Iorwerth ap Madog, a family of Welsh lawyers, it's called. Excellent journal article. He really got to grips with who these people were. Now, the first redaction I want to talk about is the Cyfraith redaction, which is named after Cyfraith, Cyfraith ap Morgennau, Cyfraith, son of Morgennau. And if you look there, there's Cyfraith and there's Morgennau, his father. Now, the father and the son were lawyers. Cyfraith and Morgennau were both lawyers. So there's a section of another law manuscript which says that Iorwerth ap Madog, who was writing up his own, this chap here, Iorwerth ap Madog a Proud, who was writing his own law book, he drew on the book of Cyfraith ap Morgennau. So the son probably had a written book, and this book was possibly well known, or at least known in a small circle in Gwynedd at a certain point in time. But Cyfraith and Morgennau were from a Gwynedd-based family of lawyers and also poets. And they held land in Dinas Dinlle, just outside Carnarvon, near the beach. Yeah, that area. And this family tree is the family tree, the originator, the earliest member is Cilmyn Droed, who is Glyn Llifon, which is not far from Dinas Dinlle, actually. The modern day stately home called Glyn Llifon is not far from there. Anyway, but it's that family from that region. And Cyfraith and Morgennau had land originally in Dinas Dinlle. Then they were invited to Anglesey. And David Jenkins suggested they were invited to Anglesey to fill judicial posts, which implies quite a sort of formal structure, but whatever, they were invited there as lawyers. And they were given land in Llanddyfnan near Talwrn, just outside Llangefni, in the middle of Anglesey today. It's where I was brought up, very near where they allegedly went. And they were clearly rewarded and were well known as lawyers. So they probably did go to Anglesey as lawyers. So that's Cyfraith and Morgennau. So one redaction is named after Cyfraith. Then the Iorwerth redaction, possibly the most famous and the most famous lawyer, is named after Iorwerth ap Madog a Proud. And this is the subject of David Jenkins' study. Now, Iorwerth ap Madog a Proud, who was writing, his floruit is around 1240 maybe to 1268 maybe. He lived in North Wales, in Gwynedd as well, and he's named as being responsible for a section of the redaction that's named after him now, the Iorwerth redaction. Now, I haven't pointed out, but Iorwerth exists here. This is Iorwerth ap Madog a Proud. So he's related to Cyfraith and Morgennau. They're all from the same family. And incidentally, Iorwerth ap Madog was a cousin of Gruffydd y Brynwyr Coch, the poet, whose father was a justice. So they're all in the same family. But Iorwerth ap Madog a Proud, from a family of poets and lawyers, I'll be talking quite a bit about him shortly. The third redaction I will mention briefly in passing is named after Blagorid. Blagorid ysgolhaig, Blagorid the scholar, although ysgolhaig can mean, it can mean a cleric as well. he was probably a cleric or a scholar rather than an actual lawyer from a family of lawyers. It's quite an abstract contribution that he made to the laws. He's only named in the prologues to the Blagorid redaction. He's not named in the others, but all of the others are named throughout the law texts. And he probably existed. There are men named Blagorid, which is a slightly odd name, not that common. There are men named Blagorid in the Book of Llandaf from South Wales, a clerical book. So he was probably a clerical lawyer, but that's as much as we know about him, and we can't link him directly to any aspects of the laws, whereas the others usually can be. So there's some famous lawyers, and keep Iorwerth ap Madog in mind. So what did these lawyers do? Well, the law books help us again. I did mention that I'm married to a lawyer. Well, that's my husband there. On the day he was formally appointed a judge, and those are my children who are not appointed as judges and will are not allowed to sit in justice in any way, shape or form. So it's difficult to pinpoint exactly what these lawyers did, but there's some evidence in the law books themselves. As I said, they were very high-ranking men, the lawyers, but then again, they were writing the books that said where everybody stood in society, so of course they were going to put themselves at the top. But they were very important with the poets in the royal court. They worked with words, learning and skill, and they had something that other men didn't have, this ability to deal with words, poets in the same way. There are various names, words referring to these justices, if you like. Justice is a general term. We've got the word ynad, which comes from the Indo-European root gna or gno, meaning knowledge. So it probably originally meant the ones, or what, wise man, or the one with the knowledge. So a special designation. So ynad is very important. This is from Geiriadur Prifysgol Cymru, the dictionary of the Welsh language. And the first translation is magistrate. That's because in modern law, the word ynad has been used to refer to a magistrate. Actually, in the Middle Ages, it was a senior ranking, so justice or judge would be better, but of course the modern usage takes precedence here. And then the other word that's used commonly in the laws is brawdur, from brawd. Brawd seems to mean to categorize or to decide or something along those lines, to decide mainly. So this is someone who judges, or a critic, if you like, but brawdur. So these are the two words that I use. I use justice generally and sometimes judge. But what did they do? Well, it depends. And who were they? We have a north-south divide. According to the laws, there are three kinds of judges or justices in Wales, according to the Law Hywel. The judge of the daily court by virtue of office. Now, the court justice is a very important and high-ranking man because he sits always with the King of Dynevor in South Wales and the King of Aberfraw in North Wales. So he is sort of the top man in the legal profession in Wales. And then one judge of Comot or Cantref by virtue of office. Now, these are the regional judges. The Comots and the Cantrefi are the sort of smaller local divisions. And they're your circuits judges, the ones that are doing the hard work all over the region. In every court of pleading in Gwynedd and in Powys. Gwynedd and Powys seem to be following a similar setup. And then there's a judge by privilege of land in every court of a Comot or Cantref in Deheubarth, namely every owner of land. So in South Wales, in Deheubarth in South Wales, they had non-expert judges. It's a bit uncertain exactly what they did, and how they got there, but I'll talk a bit more about that soon. So these are the landowner judges. The professional justices are the main ones. That's the sort of creme de la creme. That's the one you want to aspire to. But then you probably have landowners and less expert judges, particularly in South Wales, probably because there wasn't enough of the highly trained judges and there's only so many people from one family that you can get. So probably they had to widen the scope a little bit. You've also got references slightly later, beyond post-conquest and in South Wales, to the dosbarthwr, the one who sort of distributes things or makes decisions again. Now, the dosbarthwr, there's very little evidence for these landowner justices outside of the law text, but you do have evidence for dosbarthwyr, who may be a similar thing in South Wales. They were men who had expertise in Cyfraith Hywel, in Welsh law. And they were usually, we have some evidence for them outside of the law books, they were noblemen. They often played a very important role in cultural and literary life in Wales, and they were paid by the crown. They had some legal expertise, but perhaps not as much as the ideal court justice with all the training. So the situation in South Wales is largely these crown-paid dosbarthwyr and less sort of elite judges. And it's probably the same situation in the March. It's a very different situation with very different needs to what was going on in Gwynedd, according to the law books. But the law books are presenting an idealized situation where you have highly trained lawyers. So how did you become a lawyer? Oh, sorry, first of all, what did the lawyers do? I haven't mentioned that. So what did the lawyers do? Well, according to the law books, those are three very famous lawyers. No, actually, there's only one famous lawyer in that picture, and it's not me. But I love this picture because that's Lady Brenda Hale, who was then in charge of the the Supreme Court of England and Wales. That's a facsimile of a manuscript, but yes, I am holding a manuscript as if I'm holding some, I don't know, cheap novel. It's quite funny. Anyway, the law books tell us that three things pertain to a justice. So justices are supposed to do three things. They issue pronouncements at the king's need. They set forth and settle disputes in court, which is probably their main role. And the third is that they determine things by judgment, and they must confirm this by a pledge and a law book. If the king asks. So they've got to show their legal knowledge to back up their judgments. But basically, they're working on behalf of the king, making official statements and probably giving the king direct legal advice. But they're also doing the role of a judge and deciding cases, concluding cases. But they also seem to have been working as sort of legal advisors as well. They seem to be mixing quite a few roles, and it probably depended on who they were, where they were, and what was required of them, and what status they had, and how much, how experienced they were, etc. But they had various roles to do. So becoming a lawyer, well, apart from being the son of a lawyer, there are steps on how to become a lawyer, and they're detailed in a section of the third part of the Iorwerth manuscripts, which is called the Iorwerth test book. I really struggle to say that. So it tells you how to become a justice. So if you want to be a justice, you have to know this book, and that's the test book. The test book is comprised of these are two versions of it, the short version and the long version. The test book is comprised of the value of wild and tame, so on animals and their values and compensation payments, and also the 3 columns of law, which is the equivalent of criminal law on homicide, theft, and arson. And it says that you have to know the book, the test book, really well. And when the teacher sees that he's sent to the court justice, and the court justice tells the Lord, yep, he's all right to become a lawyer. Or in the longer version, the court justice tests him to find out if he's learnt it well enough and if he knows the book well enough. And if the court justice finds him worthy, he's sent to the Lord, and the Lord grants the office. So the Lord or the king grants the office of judge or justice to the would-be lawyer, and then he's fully qualified. And he also has to pay the court justice for testing him. So the court justice is clearly the head of the profession there. So they're expected to know certain things. The Blagorid texts from South Wales also have a similar section. But this is interesting. If the king wishes to appoint anyone unskilled and unprepared in law as a court judge, it's right for him to be in the court in the king's company, listening to the justices, learning the laws, sort of observing and seeing what's going on. And above all, they have to learn the 3 columns of law, homicide, theft, and arson, and the value of all tame animals and other wild animals, so the value of wild and tame. So that's what became the test book in the Iorwerth manuscripts. And they also have to listen and learn on the job, if you like, do a work experience for a whole year. And then nobody is allowed to be a judge, save him who is taught like that, or who is learned in law. I like that because it gives you 2 options. I don't know where you get your legal learning if you're not doing this on the job training, but you'll swear that you won't judge falsely ever. So you have to sort of, you have to train properly. Then they're not willing to have people who don't know what they're doing sitting in judgment. So how do you get this legal learning? Well, there's no evidence of actual law school, legal schools, but we do have evidence for poets' education, and we can assume that they worked in a similar way because it was a similar kind of thing, which sounds odd, but it's true. But you do get references to learning these set texts in the laws. You get references to learning the 3 columns and the value of wild and tame. In fact, the law books themselves are often said to be rather silent on practical considerations, such as how to be a lawyer, probably because that's not what the law books were for. You don't need to learn court procedure and the like from your law book, because you'll know it from either sitting in or have it taught to you in some other way. The law books tend to give scenarios of legal situations, but not the actual mechanics of holding court cases. On the whole, there are some examples. But the later law books and the reworked bits of Iorwerth, the third part of the test book, which I'm talking about quite a lot tonight, they give more information on procedure and the practical aspects of using the laws. And there are some texts which might be linked to learning or even to law schools, or even texts within the law books that could be used by those who wanted to practice law or needed to practice law, but were perhaps less familiar with the mechanics of it. These would be people in post-conquest Wales, particularly in South Wales and definitely in the March. And there are Marcher manuscripts and manuscripts from South Wales, and that's where you find this kind of material. So it's sometimes assumed that the poets and indeed the lawyers as well had oral learning, that everything was learnt off by heart. But the lawyers were certainly literate. We're less certain about the poets, but the lawyers were certainly literate. And the use of law books in court and the emphasis on writing within the law books show that they needed written work. And that's what you have in the manuscripts. But there is some evidence of oral learning. For example, mnemonics. Now, my first book was actually on the triads. My doctorate was on the triads, the legal triads. There's long collections of legal triads, which are basically sentences listing things in threes. Here's some examples, all related to the laws, although some of them are a little bit out there. The second one is one of my favorites. 3 things which are not paid for. You don't get compensation if you lose these things, even though they're lost in a trandy. Trandy is sort of like a B&B, but slightly less. Well, yeah, it's not a nice place to be. It's a fairly rough lodging house. So if you lose these things, you don't get them. You don't get any compensation for them. You don't get them paid for. A knife and a sword, because you don't leave them and you keep them with you. And also they're quite hard to distinguish between them. And also your trousers. So keep your trousers on at all times. So these triads, there's large collections of them. It's not fully straightforward. They were literary devices as well, and things were written following a tripartite formation, but so the shorter triads may well have their origin in oral learning. We've also got these very interesting sections now. That's the Lord Chief Justice in the background of the shot there. Lord Burnell, I think his name is, of Malden. You've also got these sections called interrogatories, and in one manuscript there's a sort of introduction to them. It says profi ynad weithion, now testing judges. And this is precisely what they seem to be. They seem to be texts that would be used for testing whether judges know what the laws are. They're quite interesting because they give exceptions and unusual situations. Is there one case where a sale thief's life is forfeit before he escapes? So a sale thief is somebody who's been accused and found guilty of theft and would be hanged unless he could buy his own life for £7. So if he escapes, then he lives. But he loses his life because if he's able to buy himself, he's got the money, but he, for some reason, doesn't do it, then he gets hanged. And then is there one galanas, a death that doesn't have sort of an abetment, as in a payment for the deliberate, or premeditation in many ways? Yes, if an animal kills a person, you might have to pay the life value, but you wouldn't be paying anything else because it's an animal killing a person. But these seem to be tests. You can imagine they would be asked from a teacher of a would-be lawyer, maybe, and the title suggests that as well. They're very rare survivals, but they do occur in some manuscripts. There's also models of how to do things. There's very detailed models on how to hold legal cases. in the law books, and they include a seating plan of where you sit in court for a land case. And there's also models of how to write a plaint, which is the initial sort of opening part of a court case, pretty much directly equivalent to the modern day claim form, which is the new word that they brought in the 90s instead of writ. But the claim form is what you have to fill in to take a case to court in modern day terms. And you have to state the name and address, state the name and address of defendant, and then brief details of the claim. And that's precisely what you have in this 15th century text called a plaint, which is a plaint regarding a surety. Surety is somebody in a contract. The substance and course of my plaint is namely that the present N, and you put the name of the person in, came in a known day, none other than, and it tells you this is when you say, name and address and time and date. And the present person came and became a paying surety, and so on. And so this model actually gives you gaps, so you can adapt it and put your own details in there. These are generally found in later manuscripts, and they're clearly for lawyers' use as a handy guide of how to write these things, or how to present them if you're not writing them, but the gaps left for you to fill them in. The later law books were certainly important for learning the craft, and whilst they're not textbooks as such, they were used, and perhaps having guides and models was more important both in the post-conquest period, but also outside of Gwynedd in the March and in South Wales. Now, to finish sort of the next 10 minutes, I would like to look at the evidence within the law books of sort of learned lawyers, well-known lawyers who wrote law books, and the importance of the law books and why we have so many law books. Now, the best lawyers are often named in the law books, and Iorwerth ap Madog is the main man, because we have a prologue to the test book, and it says that Iorwerth ap Madog compiled this book. So it says that he wrote this section of the test book, and he compiled it from the book of Cyfraith ap Morgennau. That's Cyfraith, a distant relative of his, an ancestor of his, and from the book of Gwair ap Rhifon, the book of Goronwy ap Moruddig, and from the old book of the White House. And in addition to that, from the best books that he found also in Gwynedd and Powys and Deheubarth. And this book is called the Llyfr Prawf, the test book. That is the 3 columns of law, the value of wild and tame, and other things. The other things have been a matter of some debate. Now, very important, Iorwerth ap Madog, he was clearly writing his book, but he had other books, quite a few other books. He's got Cyfraith, Gwair, Goronwy, the old book of the White House, and at least 3 other books. So he's working with about 7 books or probably more. So he's not writing something new. He's rewriting, he's revising, not composing anew. So we get it, and some of these books are attested. Now, Iorwerth ap Madog was working in Arfon Uwch Gwirfai. That is the church of Clunog Fawr by the sea on the way down to the Llyn Peninsula. A fine church, well worth a visit. It's a fantastic location and wonderful church, very old church on the pilgrimage route to Bydd. And that's where he was working, it seems, in Clunog Fawr. So he was working there, and he was rewriting the laws from existing texts. This is important because the law text might seem old, but learned men were allowed to adapt and rewrite and edit, or even create their own legal texts. And that's what Iorwerth ap Madog did. Iorwerth ap Madog in his day, according to David Jenkins, he was regarded in his day as a high authority on the law. And indeed he was, but he was drawing on the work of other high authorities that had gone before him. And we get some evidence for them. For example, Goronwy ap Moruddig, one of the men named in that prologue on the previous slide, he's referred to in the laws. There's a rule that's actually attested to him. And it says, Goronwy ap Moruddig, oh, it's an interesting rule actually. Goronwy ap Moruddig stated that a man, despite copulating with another man's wife with the wife's consent, shouldn't pay anything to the man, to the husband, as long as she praises the. If she's okay with it, he doesn't have to pay compensation for his affair that he's having. But if the deed is publicly known and it becomes common knowledge, the man is cuckolded, so therefore he has to pay, the wife has to pay her sarhad, the insult payment to the husband, or the husband can kick her out. So a really bizarre situation of an affair that was clearly, well, I don't know, do affairs ever not get out of hand? Either way. But Gronwy ap Moruddig was very concerned about these husbands being cuckolded, and so he made that rule. And that suggests that he had a written, well, there's a rule that might have been drawn upon, but it suggests he might even have had a written book. And there is no reason to think that he didn't, because it says in the prologue that Iorwerth ap Madog used the book of Gronwy ap Moruddig to create his own book. There's quite a distinct possibility that these books did at one stage exist as books of law. We also get other references to well-known lawyers. One interesting one, Llyfr Cynnir ap Cadogan, the book of Cynnir ap Cadogan. Now, interesting because this is a marcher figure. He has a book named after him in one manuscript. And after the attribution that says this is from Llyfr Cynnir ap Cadogan, this is from his book, there's a text that claims to be from the book, but the beginning is marked, the end isn't. So we don't know how much of the book, and we don't know how long this book was. The text is interesting. It's quite similar to the one I took my quote in the title from. It has legal wisdom and sort of details the attributes of a good lawyer. Again, be wise and don't do stupid things. And it might be based on an earlier bit of law. There's a triad that seems to be worked sort of into a bigger piece, possibly by Cynnir ap Cadogan himself. And this suggests that the law books were open to being rewritten by expert lawyers. But Cynnir was the abbot of Llandinam. He existed, and he was the abbot of Llandinam. And he also, 14th century, sorry, and he also acted as a clerical jurist in a case in Arwystli. He's a marcher figure. But the laws could be written by expert lawyers. But the definition, looking at Cynnir, the definition of lawyer or legal scholar was quite open and flexible. In fact, yeah, the definition of a lawyer was open and flexible, because he may well have been, well, his main job was presumably as a cleric, not as a lawyer. Throughout the laws, we also get references to other views. There was plenty of legal discussion going on. So, for example, we've got this first one. Some say that a gage is not forfeit from the hand of a surety for a period of a day and a year. The law says that a gage is forfeit from the hand of 3 persons, blah, 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 details who they are. So some say, and the law says. And then there's a very good one here where there's quite a lot of debate again. Some say when a man's been cut off from everything, that is cyfarch cyllell, is a fiendishly difficult bit of law, which I'm not going to explain. Others say it is when an oak is felled without permission. The whole thing is murky. And then Iorwerth ap Madog, however, says that this is rightly this situation. So what we've got is legal discussion being held. Some people are saying this, some people are saying that, but generally they say the law says this is the answer, or even better, Iorwerth ap Madog, our famous lawyer man, he says that this is the situation. And I'll turn back to that briefly in just a second. But what we know is that these law books, there were trained professional lawyers who had legal learning, quite a lot of legal learning. And we know that they wrote books of laws, and some of them were attested. But why were they doing this? Why this, thriving discussion and debate about the law? Well, the law books themselves, the surviving law books, are all intended to be authoritative books of law. The prologues state their authority. They link them to Hywel Dda, King Hywel ap Kadesh, who died in 950. And there's also a recognizable form of the law. This is how the law books can be grouped into categories, because they all contain similar, well, the same section in a similar order and content. So there's certain sections that are sort of recognizable and perhaps traditional, if you like. They're well-known sections, but they've often got titles. This is the law of women. Everybody knows that's a bit of the Welsh laws. And these traditional sections give the laws authority, but there was also flexibility. Books were being rewritten and scholarly work was being carried out, in Gwynedd, certainly, in the 13th century by Iorwerth ap Madog himself, among others. Iorwerth was reworking the test book. That's the third part of the law manuscripts and of the Iorwerth manuscripts, and the bit the lawyers needed to learn off by heart. So the authority of the law is in the traditional tractates, parts 1 and 2, if you like. But the third part was the bit that was mainly used. It was the bit that had the practical application and the administration of law. So why are all these law books different? And why all this rewriting? Well, in the law books, there is reference to choosing the best judgment in a legal case. And some of these law books would be books, the later ones, the third part, would be books of best judgments. The Blagorid manuscripts often regularly emphasize the importance of consulting books in order to practice the law and how to conclude cases, giving the best outcome. So written judgments are the trump card. So this is a bit on deciding a legal case. The king hears it, then the person speaks about it. Then the person, so somebody's not happy with the judgment they've had. The person who speaks against the justice, so he's questioning the lawyer, is to produce from a law book a more correct judgment than the one which the justice produced, if he can. I think there's quite a lot of power in if he can there. And so he overcomes his justice. So if you don't like the judgment, you can question it if you can bring a better judgment from a law book. And if you can't, the advantage belongs to the justice, because no one can discredit its judgment against the pledge of a justice unless you can produce a more worthy decision in written law. If the dispute of the two is against each other in written law, the decision is being referred to canonists, more experienced in truth, and the one seen closest to the truth is the one worthy to be maintained. But there's a massive emphasis there on written law. And then the second section, if anybody states that the justice has judged a wrong judgment, so not just not happy with what you've had, you're saying it's wrong, then let them both place their pledges in the hand of the king. The justice is defeated and written law shows that he is defeated. He has to pay the king his office and the value of his tongue. That's the value of the justice's tongue, which was, I think, 120 cattle. It's a huge amount, into the hundreds of thousands. And from then on, let him never judge again. So you have to show things in written law. Now, so the written law is the trump card, but it also assumes that the justice has worked hard and looked at lots of books, which is why we have many books. But it also seems to suggest that the claimant could also find a better written judgment. Now, the question is that likely? Is a layman who's just been to court and fought his battle, is he likely to A, be able to read, B, be able to have several law books, access to several law books, in order to find a better one? He may have a legal representative, of course, but the chances are that this is a warning. You know, you can challenge your justice if you like, but you're going to have to beat him in legal learning, and you're not going to, because you don't have the background and the legal learning that they have. So several books are needed in order to take this process, but they're essential, in fact, but it might explain why there are so many law books, but the law books very much belong to the lawyers and were a bit of an exclusive preserve for them. We also get references to written law. So, for example, sworn appraisal, a value is to be applied to everything which does not have a written legal value. We've got a list of values of everything. You have to swear to the value if you don't have it. So we've got that, and we've also got references to the written tradition in sentences, say, as we have said above, etc. And there's also these two sections, not the first one, but these two sections, which show how you can adapt the law by using unwritten law. You can include it in your law book, because you can't write everything you need in law. So therefore you can include stuff that isn't written if it's good, and you can incorporate customs, again unwritten, if they're good, and it tells you how a custom is decided to be good and how it's not. So this is how and why the law got into the law books in the first place. The law books were needed to determine whether a certain decision was correct or not. And custom and legal custom is a complex thing. But Davies Jenkins states that the general principle in our period is quite clearly that the authority of a legal rule comes neither from custom nor from the sovereign, but from its being written in a law book. The Blagorid law books, the Southern texts and the Marcher texts, were needed to support judgments in court, and as a result, they're presented as definitive, with authority, leaving no room for doubt. However, the Cyfraith manuscripts, with their origin in a different situation, a learned circle, show that the law was under debate, and there are sections which show different views with a correct answer given. So to conclude, the lawyers and the law books can't be separated. The lawyers were writing the laws, but they were doing it for their own purpose, and that was with an eye to using the law books themselves in order to practice. Law, unlike other written forms from medieval Wales, was dynamic and had to be flexible. They had to be able to move with the times, to adapt, be open to including new ideas or changes in society. And this ability, the ability to do this, was written into the law books themselves. The law also had to appear authoritative, definitive, and so referring to written law could give authority. Referring to well-known authors would also do this. But we still see the workings in some of the law texts. We see the debates in some sections, often with a firm resolution or the correct path stated at the end, sometimes attributed to Iorwerth Madog, to give the opinion of a learned lawyer, well-known learned lawyer, or sometimes saying the law says, and that's the one you follow. The named lawyers, it was often hard to determine exactly what was their work, but that's the point. They weren't creating new works, they were adapting, they were drawing on a long written tradition, they were rewriting. They were open-minded, they were happy to include borrowed legal concepts, for example, from England and further afield. And because they were open to all sources for making their books, the forms their books took varied too. The main aim is always to keep the law workable. So I'll end with another quote from Sir John Baker. As books became the repositories of legal learning, so lawyers became hungry for books. And nowhere is that more true than in medieval Wales. Thank you.
Thanks very much, Sara. That was fascinating. So much to take in. And certainly I've got a number of thoughts and ideas and questions formulating in my head. That was really fascinating. Some brilliant insights. So thanks very much. I think just to give people a chance to begin to formulate questions, I'll just do a couple of formalities whilst people are beginning to think about their questions and type them. So I'm just going to share screen. And just to, if it wakes up, there we go. Just to remind people that we've got 2 more talks to come. Next week, when Dr. Georgia Henley will be talking to us about Gerald of Wales, a 12th century rat. Dr. Ryn Emlyn, who spoke at the half-day conference, is talking about Walter Britt, astronomer, farmer, heretic and rebel. And I know from what I know of both those talks, they are both going to be fascinating. And then just looking further ahead, there's our AGM in Alton on Saturday, the 25th of March. Spring conference in Ludlow on the 20th of May on marriage, sex and dynasty building. The John Grove Memorial Lecture is being given by Dr. David Stevenson at Powys Castle on Midsummer's Day, the 21st of June at 7 o'clock. And then to sort of conclude the first part of the year, the highlight, I think, of the year, if not for many years, is our adventure to London when we have our conference in the Tower of London on Tuesday, the 1st of August, which is to the day the 700th anniversary of Roger Mortimer's escape from the Tower. And so it's a conference to mark that 700th anniversary, but also to celebrate the launch of the new book that is being commissioned by the Society. And as usual, just a reminder that if you aren't a member of the Society, then you are very welcome to join. Just go to the website Society. Right, I think we're beginning to get some questions. In English, please, not in Welsh. one of the things that I found sort of thought-provoking there, what was coming through, Sara, was the sense in which the law has an independence. Because it's not the king's law.
No, it's not. I mean, they like to think it is, or rather, they like to present it as the king's law to external eyes, if you like. So the laws all have this attribution to Hywel ap Cadell, King Hywel the Good, 10th century king. Whether it's true or not is another matter. And they also, the first part of the laws, because I talked about the third part, but I didn't actually say what the first and second part was. The first part is the laws of court, which details the royal court, the feast, the officers serving the king. But actually, no, this is not a royal law. This is lawyer-made law for the lawyers, by the lawyers. And the sort of emphasis on the royal court is a little bit, well, fake in a way. It's for show. Because the laws were being regularly criticised by Normans in England, Norman clerics and the like. John Peckham famously said the laws are written by the devil himself. So they're always very keen to emphasise that these are royal laws, not just, you know, made up, randomly made up customs and the like. It is an official law. But you're right, medieval Wales is said to have had one system of law for the whole of Wales, which applied to all of the Welsh. Now, this would not work if you were dependent on having a unified ruler, because Wales did not have a unified ruler. Wales was separated into regions with different rulers at different points of time, and you've also got the March. What it is a law that is made to function whatever's happening at the top level. So it doesn't come from the king. It's not a royal law. They might pretend it is from time to time, but really the lawyer is as important as any, well, it's more important than most people, actually. Yeah.
But do we get any sort of sense that could create conflict between the lawyers and the rulers?
We don't get much, but we do get examples where you've got named rulers. Bleddyn ap Cynfyn is one. Bleddyn ap Cynfyn of, well, he was king of Powys. I mean, yeah, but he's sort of named in the laws as somebody who changed the rules a little bit. Now that's one thing, and Bleddyn ap Cynfyn's rules seemed to be okay; they were accepted. But other rulers, Rhys ap Gruffydd, he's also named, and his rules weren't accepted. So it seems the lawyers could do what they like. The rulers could try and change the law to suit themselves, but the lawyers might say, "No, actually, we're not going with that. Rhys ap Gruffydd may say this, but the law says this." And then famously, I think, Llywelyn ap Iorwerth did try to mess with the Welsh laws in many ways. He wanted to change the succession laws so that he could favour his second son, which is completely contrary to the rules in Welsh law. And he did this, but it didn't go down very well at all. And it was the cause of some upset amongst, well, the ruling elite and the Welsh in general. So yeah, I mean, he tried, well, he obviously favoured his first legitimate son, but in Welsh law, the first son could inherit, they could all inherit equally. So yeah, he did break the rules.
And can we tell much about the position that lawyers, judges held at court? Has anybody, excuse me, has anybody looked at where we know the names of lawyers and so on, whether they then appear in charter witness lists?
There's very little evidence. That's the problem, because, well, we don't have court records from Wales, not from this period, and it's usually English law. We've got, there's a good set of records from Aberystwyth in the 1340s, I think, but they're English law being administered in the court, so these are not the Welsh lawyers. We don't know who the lawyers are. We've got Cynnydd ap Cadogan, of course, I refer to him. He's mentioned in witness lists. Iorwerth ap Madog and the other lawyers, they don't seem to come up, even though he was probably writing during the, well, he most definitely was writing during the reign of Llywelyn ap Iorwerth, but we don't get him referenced in charters and like. Why? I don't know. Probably because he was busy with the laws.
Yeah. John, I'll come to you in a second. If we take the question from Aled next. Can you see that chat, Sara?
Oh, no, I can't. Hang on a minute. I closed it.
I think, well, Aled starts with a greeting, which I won't find out.
It's very complimentary. Yeah. No, he thanks me for the... Yeah.
You've talked very interestingly, excuse me, you've talked very interestingly about classic Welsh law in its heyday. Could you tell us briefly a little about the later attenuated survival of Welsh law in the Marcher lordships?
Oh, see, briefly is the problem there now. Now, I've just published a book talking about this. British law, medieval Wales. That's the brief, that's my brief explanation. Yeah, I think traditionally in the historiography, there's been a lot of emphasis on this golden age, the classic Welsh law in Gwynedd, under the princes of Gwynedd before the conquest. But actually, much of my work is on the later manuscripts, and much of the manuscripts, to be fair, 14th and 15th century texts. I specialise in the 15th century texts. Several of them exist, well, several of them I have been shown, some by me, to originate from, well, places like Northeast Wales / the March, I would say the March actually. And we've got a 15th century text from Cefn Llys, for example. So we've got Marcher manuscripts, and they are very different. And I think that's one reason, and there's a massive backstory here, which I'm not going to enter, but that's one reason why these texts have been overlooked to a great extent, because sometimes they might contain a recognizable, one of the traditional classic texts of the laws, but they also have quite a lot of other material. And the other material is, to me, the important bit, because it tells you what the lawyers needed, what was required at the time. You've quite a lot of the earlier stuff, the classical stuff, is actually obsolete. And it's quite clear that you've got a very different situation happening on the ground in the March, particularly. The March, where they were still using Welsh law when it suited them, right up until the 15th and 16th centuries to some extent. Manuscripts were being produced in the March. Yes, they sometimes included the classical texts in order to give the authority, in order to show this is Welsh law, but actually the bulk of the material is this other stuff that's needed. But yeah, I say a lot about that in the book. In fact, that's mainly what the book is about. So yeah.
Okay, right, John.
Oh, I can't hear.
No, John, we can't hear you. No, still no sound. No.
Now.
Yes, that's all. There's a bit of feedback, but yeah.
Okay. Is there any evidence, any centres where they were mass producing law books for all these aspiring lawyers?
The quick answer is no. Probably because quite a lot of the law books, they've been, I reckon that the law books we have, yes, we've got 42, but they're the tip of the iceberg. They would have had dozens more if they were practicing law as they suggest in the law books, and there's no reason to suggest they weren't. There's no evidence, because none of the law books we have are copies of another one. But there are certainly groups of texts which were clearly circulating in a particular area. There's a group of three manuscripts which have the same text in it, all from Northeast Wales. They're Marcher texts, and they actually, as it happens, have a special text of model pleading, again suggesting that this is what they needed in Northeast Wales. They didn't need the other bits of the laws, they needed model pleadings. That's as close as I can get to sort of mass production, sort of the same text being copied. But otherwise, the manuscripts are generally not copies of each other. In fact, with some of them, finding the textual relationships is really quite hard because there's too much differences. It seems that the manuscripts we have were all produced for individuals, and they're very specific in nature. But you do see shared texts that were important.
And a question which got left hanging over from Saturday afternoon a week and a half ago. When Hryn, I think I've noticed that Hryn is with us. When Hryn was talking about Welsh and the universities, somebody asked, do we have any information about whether Welsh lawyers were going to universities?
Not in the earlier period.
No, I was thinking in the later period, yes.
Yeah. Yeah, good question. I don't have it. I think it comes in later. Funnily enough, the Welsh are sort of fairly famous as lawyers. The Welsh seem to be, so if you look at the Inns of Court, Gray's Inn is known as the Welsh Inn. And it's traditional for the Welsh lawyers to go to Gray's Inn. The Welsh judiciary are all Gray's Inn guys, so and women as well. But yeah, they're all Gray's Inn. So there's a long tradition of Wales and the law. But of course, one of the problems is, until the Victorian times, if you studied law at university, you were studying clerical law. You were studying canon law, not actual, well, sorry, I shouldn't say that, but not secular law, is what I'm trying to say. Yeah.
Yes.
So, but no, I don't have any evidence for this.
And presumably this was a system of law controlled and run by men. There's no involvement of women at all?
No. In fact, women are deliberately kept down in the law, so no. Yeah, this is all very male dominated, and other than the laws of women, which are only there really because they need to discuss the inheritance and the boys who are born. Other than that, it's very male dominated. No women. Yeah. We're mainly pre-female poets as well, incidentally, just to give the poets a shout out. Until you get to Gwenville Mechain, who's considerably later than these, you don't get female poets either, really. Not that we know of.
Mm-hmm. Right, I think we're coming to an end. I was just sort of trying to get my head around the sort of example, one of the examples that you gave, which, if I followed it correctly, amounted to if a couple had an affair.
Oh yeah, so, that's a good one. I can put it up again if you like.
If the couple had an affair, so long as the woman said, "Well, I had a good time," and nobody else knows about it.
Yeah, yeah. It's slightly odd, and I don't know why Cyfraith was so very hung up on it. Where are we?
I mean, it puts even more pressure on the bloke to perform.
Well, yes, it does. It does. It's slightly odd. It's and why is Gronwy Morivig so hung up on this random? This is the rule that's been, it's that thing. How do you want to be remembered? Poor old Gronwy Morivig. We don't have a book of law. He might have had one. He's named as being the author of one, but this is the bit that they carried over. Yeah. So this man has had an affair with somebody else's wife, and the wife is okay with it. In fact, yeah, she's happy with it.
Well, praise is the deed, in fact.
Yes, indeed. Yeah, although a wife must never, ever criticize her husband in public, because then he's allowed to beat her or get compensation from her. And if the deed is publicly known, and I think that's the thing, once things get out into the public, the man might know about it, the husband might know about it, but once it's public, then she's criticizing him, sort of, because you need to take another man because he's not good enough. So yeah, that's when the wife has to pay the sahar. The man having the affair, all he has to do is, well, turn up and do the job, really. It seems so. Yeah.
To her satisfaction.
Yes, indeed, to her satisfaction. Yeah.
There's a couple more questions. Rhiannon, do you want to? I can see Rhiannon. You've got your hand up.
Unmute. Yeah. Just comment on that, really. It seems to be much more about reputation. The concern is about the husband's reputation not being destroyed, being publicly cuckolded. But what I think is interesting is that there's no obvious concern about parentage of any children as a result.
No, that's a point, and they're very hung up about it normally. Yeah, reputation is everything. Now, the payment is well, the modern word that derives from sarhad is sarhad, meaning insult. And it's also, in some circumstances, in the law of women, it's called wynebwyr, face value. Reputation is all. But yeah, I think, well, the thing is, if a child is born to a woman, if the father acknowledges the child as his own or brings him up as his own, I mean, if the father gives goods for bringing up a child, he's acknowledged paternity. So don't ever give a teddy to a child unless you're certain it's your own. But if that's the case, it doesn't really matter who the actual father is. They're really not that concerned about it. My favourite sort of equivalent is in Irish law. They do try and work out who the father is, and if there's a facial similarity, then you could have a child assigned to you. You know, the milkman is the only ginger in the village, and therefore he must be the father of this ginger child. No talking of yeah, but yeah, as long as the father acknowledges, and that was highly criticised by the Norman clerics again, because the Welsh were immoral, because they had quite a relaxed attitude to paternity and the relationship of the parents. All they needed to make sure was that the father acknowledged the child as his own.
Okay, well, right. I think there's time just for one last question, because we need to let Sara get away to watch herself on television. So
or a large drink.
Yes, indeed. A last question from Stella, who's been on the telephone all night.
Oh.
Yes, hello.
Hi.
That was all incredibly interesting. But throughout, I've been thinking, presumably each party resorts to a lawyer, but who actually makes the judgment?
Yeah, it's not really made clear in the laws. It seems that you had various ranks of lawyers. Certainly you have the court justice, who's the high ranker. And in the description of the court seating in a land case, you've got various people called the canllaw. Canllaw is a handrail or a helper, a guide, actually. And they seem to have been qualified, or rather had legal knowledge, but might not have been in the full ranks. So it does seem that there was a hierarchy, but they're fairly mysterious. They don't say much about these canllaw. My guess is the canllaw, and the cyngaws as well is another one who sort of shares a cause with somebody, that the word means sharing a cause. I would argue that these are the guys who were doing the work on a local level. They were dealing with the clients. They are solicitors. They've got legal expertise, but they're not as high ranking, or dare I say poncy, I was married to a barrister, as the barristers, who are the next stage up. And then you've got the judges, who are the next. So it's a hierarchy, very much like it is in English law today, in England and Wales, obviously, but in English law today. It's just that the laws don't really make that very clear, probably because they don't want to. The laws want to present themselves as really the top-notch lawyers have written these laws. So there's all the others, but they don't want to focus on them very much. Yeah.
So there would be a judge of some kind who was going to make the final judgment then?
Yes. Yeah. And the king also, in the description of the legal case for land, that's the whole of this. I could have lectured for about 3 hours, but everybody would kill me. But yeah, in the description of the case for land, the king is to sit there, and the king is the main one. They do acknowledge sometimes that the king gets to be the ultimate judge, but actually they also say, well, yeah, if the king's not around, the judge will be the ultimate judge. The court justice will step in, and he can be the king and represent the king in all things if he wants to. So yeah, but there is an ultimate judge, and then you have the lower levels. And I would imagine they do far more work. In fact, I would imagine that the manuscripts were needed by these guys on the lower levels, not the famous ones who are poncing around rewriting bits of laws. It was
so
guys.
It's basically up to the lawyers to present the various ways of looking at it, and then the judge would just judge that rather than the laws themselves. Yeah. Mm-hmm. All right, thank you.
Okay, thanks, Stella. Right, well, that's been brilliant evening. So thanks very much, Sara. I think that's given everybody a lot to think about and a lot of insight.